punish the respondent. We came here.
Your Honor, we will object to that kind of language.
I am
No, I will not let it that go. Your Honor. The state.
We can fight over this for hours.
We will fight.
And let me finish.
Your Honor, don't allow that kind of language to be used in your court.
Mr. Osorio,
Let us be polite to one another.
is it okay? That's Mr. Osorio.
Yes.
Proceed.
Maybe Your Honor, then maybe let me paraphrase. The state has resorted to shifting goalposts. Your Honor, the ruling that was read by this Honorable Court on the 2nd of May, specifically order number 2, that this matter shall be mentioned on the 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and for further orders. The court never asked for further affidavits. The status report on the investigations. You expected to come with the attachment or tell us that this is what we've done, or give us some evidence. We even support their malicious application to keep holding on the respondent. Such kinds of documents are what the Supreme Court called hot air. It's full of sound and fury signifying nothing. And this court has the powers to arrest such an injustice being perpetrated by the state. Don't like this.
Can I say just Your Honor, you have heard the objections, and in my view, they all have merit. Your Honor, considering the time and the schedules and the need to move, I wanted to say, to request and suggest, Your Honor, that you give us direction so that we proceed, so that Mr. Kiprop, though he really has nothing to say, but can say all of it, so that we don't make application, ask you to make a ruling, we come back again, because our interest now is that Ezekiel should not be in custody any longer. The more we take you around, we may end up keeping it long. I suggest that you direct in a manner that we proceed and finish up, and whatever. And you can even order the strike note or the affidavit, and Mr. Kipro to say what you want to say, we reply, and we finish this
Your Honor, if I may, with all due respect, we appreciate what the defense is saying. And we hear their various arguments. You have been invited to look at your ruling, which was delivered on 2nd of May, 2023. And particularly, you have been referred to the last paragraph of your ruling, which says that this matter shall be mentioned on 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and further orders. Your Honor, it is upon this subsection B of your ruling that we are before this court to appraise the court on the status of these investigations, and if there are any further orders that the court will grant, then we will make that application. I'm afraid that is what the learned senior Mr. Kipro had started with. That is the first thing that in his submission he stated, that the court had directed that we appraise it of the status of the investigations. That is when Your Honor invited the state and asked whether the application had been signed. So I would agree that we can take directions based on Mr. Magolo's submissions. However, before the court does that, I will invite the court to consider two issues. Mr. Omari raised the question on the matters of civil procedure. This court is guided by the Criminal Procedure Code. And in any event, if the Criminal Procedure Code has not given express provisions on how this court is to be moved, which we are going to rely on C, where we were, one of the orders will be at liberty to apply for any appropriate orders, which we are currently doing. Then the court is also invited to look at the Constitution, where the Criminal Procedure Code is silent on the way we are to move court. Under Article 159, Your Honor, if I may read Article 159, which I'm sure the defense counsels are well aware of, and the court. 159, sub-article 2D, that judicial authority is derived from the people and vests in the people by the courts and tribunals established under this Constitution. In exercising this authority, the courts and the tribunals shall be guided by the following principles. Now that moves me to sub-article D, that justice shall be administered without undue regard to procedural technicalities. Now, if the Criminal Procedure Code, which is the basis upon which we come to this court and has the procedures by which we are supposed to move this court, is silent on how we are to move this court, then I invite the court to refer to Article 159, which is the supreme law of the land. And basic law tells us that any other law which is inconsistent with it is repugnant to that extent of inconsistency. So, even as I rest,
1 more minute.
thank you. Even as I sit down, Your Honor, I invite the court to look at that provision in light of the submissions by the defense counsel.